But somewhere I read of the freedom of assembly. Somewhere I read of the freedom of speech. Somewhere I read of the freedom of press. Somewhere I read that the greatness of America is the right to protest far right. And so just as I say we aren't going to let any dogs or water hoses turn us around.
Today we tend to think of the First Amendment protecting individual liberty. Each of us enjoys the individual or personal freedom to speak as we feel, except when we don't. There are many times and places when our right to speak is limited. Can I say, for instance, I have a bomb in my luggage while I'm on an airplane? No. Or can I falsely shout, fire, in a crowded theater? No. There are also kinds of speech in which I may not engage. I can't publish obscene material of certain styles or state secrets or false information without punishment. I can't copy someone else's speech and sell it to other people. But in broad terms, the First Amendment is now quite speech protective. It is also individually centered. It hasn't always been so. Wait, what does that mean, individually centered? Aren't rights and liberties always individually centered? In the case of freedom of speech, the answer is no. The modern First Amendment, as we know it, emerged about 100 years ago in a string of famous decisions and opinions prompted by radical political speech during wartime. Some of the most influential legal minds of the 20th century, Oliver Wendell Holmes and Louis Brandeis, were the prime movers in the legal expansion of individual liberties. But this story is also set in culture and in the lived experience of Americans who increasingly began to feel that free speech was a fundamental individual right. The cases we read in this unit contribute not only to the law, but also, perhaps more importantly, to the public vocabulary, the shared feeling of free speech in all Americans. But what came before the individually centered First Amendment? How did Americans and the courts understand their individual right to free expression before 1919? The answer is it depends. In actual fact, the area was a mess. Enforcement of anti-obscenity laws and censorship practices were widely variable by state and locality. There weren't many important legal decisions that articulated anything resembling an individual right to unfettered public speech. The power and control over speech rested with the state, the community, the majority. There were tons of radical speakers advocating for pretty much anything you could imagine: universal suffrage, free love, the inevitable dictatorship of the proletariat, anything. But these speakers in the 19th century were significantly burdened by the risk of punishment, the chilling effects, the fear of state control over free speech. The prevailing legal approach to adjudicating First Amendment matters until 1919 was called the bad tendency test. That is, a court would evaluate whether or not a speech act had the tendency to create or even suggest socially undesirable outcomes. As expressed in the case Schaefer versus United States, the state may suppress speech that has the natural and probable tendency and effect to cause criminal activity or corrupt public morals. What? That seems crazy. Restricting speech just because it might have the tendency or possibility to cause criminal activity or corrupt public morals. Now note, the court there is not requiring any actual effects, just saying, as it were, well, we think this speech is likely to harm public morals, so it's subject to being chilled. It should be suppressed. How can you apply such a test in a principled and consistent way? Sounds to me like a license for judges to enforce the tyranny of majority opinion. The bad tendency test describes a way of thinking in which the rights of the community, the majority, are enforced against the individual dissenter or the minority speaker. The bad tendency test was subjective, it was vague, it was inconsistent. It was also increasingly seen as overburdening of individual liberties. The prompt to refine this sloppy legal test into something more principled and more workable and protective of individual rights emerged during the crucible of war. During the First World War, radical activists fell afoul of new and expansive laws, such as the Espionage Act of 1917. We should remember that the early 20th century was marked by urbanization, mass immigration, and explosive industrial growth. Concentrated groups of workers in the cities, many of them only recently arrived in the United States, were often suspected of disloyalty or imagined as easily seduced by external agitators. Pacifists opposed the war on philosophical grounds. Communists called for solidarity with revolutionary workers in Russia. Activists argued for better protections for industrial workers, for women's suffrage, for equal rights for African Americans. The newspaper was the primary medium of communication. Radio and film were only emerging as influential mass media forms. Many felt the war in Europe to be pointless. Unlike World War II, it lacked a coherent or grand narrative. Defending Belgian sovereignty from German militarism was, for many, not an especially good reason to wipe out an entire generation of young European men. The ease, volume, and speed of killing during the war shattered the confidence of the age. The machine gun, the airplane, and poison gas were ample testimony of humanity's ability to devise new and ever more powerful ways to slaughter each other. So this was an age of unrest, of protest, and of anxiety in the United States. In such a moment, with communists and anti-war activists on trial, it would have been plenty easy for the Supreme Court to have just reinforced the bad tendency test. But instead, they threw it out, and they replaced it in the case Schenck versus United States with a new standard, which is called the clear and present danger test. This new standard began the long and slow march towards an individually centered First Amendment. That process unfolds in the law over about 50 years and culminates in the case Brandenburg versus Ohio, 1969. The triumph of the language of individual liberties, the feeling in American culture of freedom of speech being enshrined in our very core values, happens much faster, due in part to the charismatic philosophical statements laid down by Holmes and Brandeis in the opinions we read in this module.